when you start talking about slips and falls, how do you determine where the buck stops with these people that are elderly, with young people that have a easier time slipping and falling or having an accident than regular folks?
Bob, those are both really good questions. The first one, as far as how you determine as far as the age of the person and you know, as far as elderly people as opposed to somebody in their 30s or their 40s or a teenager or someone 7 or 8 years old, you have to take each plaintiff and each situation on its own merits. What will apply to you and to me and to Andrea may not apply to someone who is much older or who is much younger. In fact, like a 7 or 8 or 9-year-old is not going to be held to the same standards as to what we call contributory negligence, where they should have known better. In other words, if you and I are walking in a grocery store and we see a big puddle of water, in fact, let me give you this example because I had this case years ago where someone walked into a grocery store and they had to go get some ketchup, all right? Ketchup and mustard. They were making hot dogs and they saw a broken jar of mayonnaise laying in the aisle, and they could have gone around the aisle to go on the other side of the broken jar of mayonnaise, but they decided, you know what, I'll be careful, I'll tiptoe through it, and no harm, no foul. And lo and behold, this guy tried to tiptoe through the broken jar of mayonnaise, slipped and fell, and broke both legs. He did not have a case because even though there was a broken bottle, there was a defective condition there, he saw what it was, and yet he assumed the risk. He decided, I'll be fine, and I'll go ahead and go through there. Now, if this was a 5, 6-year-old, that person can't sit there and rationalize everything as well. So so you can't hold the child to the same standard as you can an adult or someone, if it's older, an older person that may not have all of their mental capacity. So you have to take each situation in and of itself.